we have this evening Tanner Rouse, who's an attorney and a former member of the Philadelphia Prosecutor's Office. We have Jamie Mogul from the League of Women Voters, who's an attorney and the vice president, and I'm sitting in front of you, sorry, the vice president of government and social policy. And we have Jennifer Riley, who is the director, the state director of Marcys Law, Pennsylvania. So we're going to have, do you have opinions about the order? Would you? Okay.
No,
we're going to have each of them speak to you for 5 minutes, and then we're going to turn over the entire affair to you. So it'll be a question and answer session. So we'll have Tanner explain things. If there's any clarification for questions or assistance for your thoughts into legalese, he's available for that. And without further ado, I guess we'll just have you start. Thanks.
So good evening, everybody. Thank you all for coming. My name is Tanner Rouse, and I've gotten to know a number of you from my time running for state senate here in the 26th district as a Democrat last year. But in addition to that experience, as Beth mentioned, I'm a former prosecutor in the Philadelphia District Attorney's Office, where I was for 7 years, the last year of which I spent in the homicide unit. Won several awards for victims organizations that I worked with during my time there as someone that had done an outstanding job in victim services. So I'm very proud of my record on this issue. And in addition to that, the firm I'm working at now, KOT Law, we have a victim's rights and a victim kind of compensation branch of our firm. So victimhood and what victims go through in the legal system is something that I've been very closely aligned with throughout my career and spent a lot of time working on and working towards. So pairing that with kind of also a perspective on criminal justice reform that I think is important and something that needs to go on, I hope represents a little bit of both sides of the coin of what we're going to be talking about here tonight, and I hope lends me a maybe not unique but pretty good perspective, and hopefully I'll be able to help moderate and stir the conversation a little bit for everyone.
Great. Well, thank you all for indulging me this evening. Again, I'm the state director for Marcys Law for Pennsylvania. So I've been in this position for almost, 2 years now as we've moved through the referendum, the ballot, and the legislative process. So just taking a step back, I wanted to just talk a little bit about why Marcys Law is even in existence. So back in 1983, there was a college student, Marcy Nicholas, who was stalked and murdered in California. And a week after her death, her brother and mother went into the grocery store after visiting her grave and ran face-to-face into the accused. And the confrontation occurred. It was very traumatic, as you can imagine. And it was at that moment that Marcy's brother decided that he was going to do everything that he could to make sure that victims and their families wouldn't have to go through what he and his mother went through. They should have been notified of his release on bail, and they weren't. And so that kind of is at the heart of Marcys Law. So what's really interesting about Marcys Law here in Pennsylvania, we started the process in 2017, right? And we did some groundwork. We met with many organizations here in Pennsylvania to just see if Pennsylvania was even ready for something like this or had an appetite for something like this, and we got a resounding yes. So in early 2018, we introduced, or at the time, Senator Reschenthaler introduced legislation for Marcys Law. So in Pennsylvania, the process to amend our Constitution, you need to introduce legislation in 2 consecutive legislative sessions and have it pass. And then it becomes eligible to be on the ballot as a referendum. So the first time we introduced Marcys Law in 2018, it passed unanimously through the House and Senate. No objections. There were some amendments that we went through because we wanted to make sure that we captured opinions and we captured the spirit of Marcys Law for Pennsylvania. We introduced it again in early this year, and it passed almost unanimously. There were 8 no votes throughout both chambers, unanimous in the Senate. And so now it's on the ballot. So to just take a step back and look at Marcys Law generally here in Pennsylvania, each state's Marcys Law is slightly different. So there are guidelines from the National Crime Victims Law Institute out of Oregon that has been studying crime victims' rights for decades. And there are a few pillars that are at the heart of what victims should expect going through the criminal justice system. To be notified of all proceedings, to be present at any proceedings that they choose to be that pertain to them, to a right to restitution, a right to be heard, confer with the prosecutor, and the right to be heard through victim impact statements at parole hearings and things like that. So, so here in Pennsylvania, we took those pillars from NCVLI, the National Crime Victim Law Institute, and we looked at what we currently had in statute here in Pennsylvania. And we wanted to mirror that as closely as possible because we didn't want to create any new rights here in Pennsylvania. We have good rights for crime victims in statute. But the problem is that we've learned since 1998 when our Crime Victims' Rights Act was passed is that we have great rights, but they're not enforceable. Meaning, if a right is violated, there's nothing a victim can do. So if they are not present or not notified of a court hearing, there's nothing they can do. If they aren't allowed to give a victim impact statement and they're not at sentencing and no restitution is attached to the docket, there's nothing you can do. So how can you have a right without a remedy? So that's at the heart of Marcy's Law. So mirroring what we have in statute and creating standing for victims so they can assert their rights in court. It's only on those very specific rights that are included in Marcy's Law. So a victim can't go in and veto court proceedings or demand that they be put on the stand. No, it's for those very specific things that are included in Marcy's Law. So that's the reason for it. So, so again, every state's Marcy's Law is a little bit different. Okay. I'm not
I didn't realize we had a timer. Do you want to finish that?
No, it's fine, yeah.
Okay. Well, first, thank you for being here. I mean, to have the state director from Marcy's Law to come, I think that says a lot.
I do live in the area.
Oh, so do I.
It's still pretty nice.
It's still pretty nice. It's still pretty nice. Yeah, okay. I live in Lower Merion, so not too far. So as was announced, my name is Jamie Mogul. I do live in Lower Merion, not too far away. And you know, I think just before we start anything, I think it's very important to say specifically about victims' rights, to be an advocate, to be a victim yourself, to come, even those who have spoken out or even those who have not. We need to recognize that victims need to be heard. And they need to be supported. So that is not what I am opposing, or the League is opposing, or the ACLU is opposing, or anybody else who is talking specifically about the law. So it's very important that I tell you that. I mean, you don't know my story, we don't know anybody else's story, but it's very important to realize this is not about opposing victims' rights. So I wanted to preface, because this is a hard conversation, this is a sensitive topic. And that I'm so grateful to you all that you're interested in learning more beyond, because I hope anybody who would be approached on the street and said, do you support victims' rights? I hope everybody would give a resounding yes, myself included. And what happened here is that through the process that this has gone, I mean, our state legislature, I can tell you, I work in policy and reform, it is very rare. It is very rare to see something pass, let alone unanimously, this quickly through the legislature. So people say to me, well, how could you oppose something like that, right? I mean, because the legislature overwhelmingly supported it. In the process of what happened, there were no hearings. So people say, why did you wait? I mean, we've seen a lot in the news that the ACLU, the League is a petitioner, so we are like a plaintiff in the case on behalf of all voters in Pennsylvania. It's not about waiting. I mean, we never actually got to make a comment or have hearings or go before the legislature. The ACLU did submit memos. I didn't actually see them till the court case. But I never actually saw the actual law. I mean, how many of you heard about Marcy's Law? Maybe you heard of TV ad? I mean, there's a lot of TV ads, there's a lot of mailers. Nearly $1 million has been spent lobbying so that you all would know that the other side, right? So it's very hard to be in this position and be a person that's perceived to be opposing victims' rights. So when we see the ballot question, have you all seen the ballot question? does anybody want me to read it? I did bring it just in case, but it is limited to some 70 words under the requirements. It is to be certified by the state AG, and the Secretary of State writes that out. So I didn't actually see the certified question in my responsibility as VP of Government and Social Policy for the League. I review bills, legislation, I advocate on behalf of the League and the League's mission, which is good government and to make sure that things like the right to vote and so forth are enforced. And I saw the ballot question and I thought, this is a lot of words and how could anybody vote no? And so then I started to look further and I realized that the ballot question in and of itself does not fully address what would be changed in our state constitution. And as was said, we as citizens, we are the only ones who can alter our state constitution. It's very powerful that it goes to us to change that, but we need to be saying yes or no to every single change to our state constitution. And I would respectfully disagree that this isn't lumped into victims' rights. There are several changes, actually there's multiple changes to our state constitution. So it's very important to know that our League challenge, the challenge to this question, is really about the form. And we will talk about some of the substance, I think, as we go along, but I really want to make sure from the League's perspective, you understand that our challenge is really making sure that we enforce what victim or not, right? That we as citizens get to choose to alter our state constitution. And so for those various multiple 9 to 12 to 15 changes that cannot even be encompassed in one question, that we get to decide yes or no. Because if we do not, that is disenfranchising everybody, including victims, from altering our state constitution. So that's really what this case is about and this challenge. And so we can't set aside constitutional rights to then discuss, who has greater rights. And I think we'll talk more about the substance and what would be changed if this did become law. And very important to note, and I'm sure you'll talk about, that there is a victims' rights statute. It could be amended to include, we are very lucky in Pennsylvania that we do have a robust victims' rights statute. It could use amending, but this is very different. This would be enshrining in our state constitution these laws and making it rights, which is really not even an argument. You cannot equate a victim and a defendant. A defendant is taking on the power of the government. They are accused, sometimes even wrongly accused, and taking on that power, and sometimes in a lot of cases do not have the resources and the means, and they have due process rights. That comes from our US Constitution, but they also have significant rights. So we have to consider what is the real argument here and what can we do to make sure, and it's unfortunate, but I think these conversations could have been had prior to coming to this point. I don't believe we were one of the organizations that was contacted.
Well, you also knew that the legislation was going through the legislative process and you didn't offer a memo, either in support or against it.
I can't speak to that because I was not part of the board at that time, but the League is a nonprofit organization. We have one staff member, but I do believe the ACLU, which is counsel in this case, did offer memos. But for the League specifically, yes, we are part of coalitions because we don't have those resources and means. We are not supported by donors in that way. So, we were actually never given an opportunity if we knew there were hearings. But again, I was not part of the board at that time. So I was just saying Marcys Law did not include the League as part of analysis of the question.
Well, we did offer the ACLU to come to the table when it was time to amend Marcys Law during that first session where we were amending. We reached out to the ACLU, many of our partners reached out to the ACLU, but they declined to come to the table to help us amend and help us strengthen it to address their concerns. So, from my perspective, we gave them ample opportunity to address these concerns and have a productive conversation, but they declined.
Okay, and we're turning it over to the question and answer session. Would you like to start us off?
Yes, good evening. My name is Eileen O'Malley Spangler. My husband Bill and I live on Lakeside Avenue in Devon. Can you very specifically tell us What else is in the amendment that is not included in these 70 words? And exactly what parts of the amendment, as well as these 70 words, do you disagree with? What do you object to specifically? But more importantly, what's in the amendment that's not in the ballot question?
It's a very, I brought for you,
Too
but
long?
it is too long, and actually,
Well-
that's part of the problem, right? We are
Can you give
limited
us
by,
3 things?
well, there's several hundred words that cannot be included, but that's really not particular to Marcy's Law or anything they're doing, but that's the laws of Pennsylvania, as to how ballot questions are written, and the process of it. But that's another thing that's part of our claim, which is you cannot really tell the full essence of what you're voting on because you were limited by that ballot question parameter. But I think going to some of the specifics about, and I'm sure you all are wondering, what is it specifically that changes? And I think this is when we start talking about the substance, and so I want to say this is not part of the league's claims. We're talking about the ballot question and you going in the procedure of things. But let's talk about some of the changes. I would say, for instance, that says that the new statute would say that a victim, or even those who are harmed, so that's not just a victim.
No, a victim is a person directly harmed, and it's in statute, and Marcy's Law refers directly back to statute, and it's only the person directly harmed, so it doesn't include communities or, yeah, it's.
Well, it would include survivors,
It
right?
would be
Like,
the survivor,
I mean,
so, so the stats, Pennsylvania statute defines crime victims very specifically. Marcy's Law very specifically says everything is defined, is provided and further defined by the General Assembly. So it refers back to statute to provide that flexibility.
the 1989.
Right, any statute, right? So if the legislature would go in and change the definition of victim, Marcy's Law would encompass that. But it very specifically says those directly harmed, and then it refers back to statute. So in statute, it says those directly harmed, not indirectly harmed, but those directly harmed. And then if it's a murder, it would be family members. So it's very specific in that.
Maybe you can discuss then the portion where it says those who shall be protected. Doesn't that go beyond that? Because it actually says in the statute that those, and even those who are assisting the accused, should be protected from harm. So it does go beyond what our statute says. And this is where I think we would disagree, but I
Jamie,
think.
can I ask, can you read the
Yeah.
passage you're referring to?
Well, I was actually going to read the actual statute, because I think
Okay,
in
yeah,
of itself.
if that's what you think would be helpful,
Well, I
that's your
think
point.
beyond the question there, you've asked, and so it is a very long statute. I mean, we only get 70 words, and so I think it's very important that, and if I'm going too fast, please raise your hand. To secure for, it says the rights of crime, victims of crime. To secure for victims justice and due process throughout the criminal and juvenile justice system, a victim shall have the following rights, as further provided and as defined by the General Assembly. So again, referring back to the General Assembly and not as defined in a statute. So that means that this statute is actually not clear. It means it's going to be further through a process that will have to go back to the General Assembly.
No, what that means is everything in Marcy's Law refers back to statute.
And I think I'll continue because I'm going to go through some of the specifics. Which shall be protected in a manner no less vigorous than the rights afforded to the accused. To be treated with fairness and respect for the victim's safety, dignity, and privacy. To have the safety of the victim and the victim's family considered in fixing the amount of bail and release conditions for the accused. To reasonable and timely notice of and to be present at all public proceedings involving the criminal or delinquent conduct. To be notified of any pretrial disposition of the case, with the exception of grand jury proceedings, to be heard in any proceeding where a right of the victim is implicated, including, but not limited to, release, plea, sentencing, disposition, parole, and pardon, to be notified of all parole procedures, to participate in the parole process, to provide information to be considered before the parole of the offender, and to be notified of the parole of the offender, to reasonable protection from the accused or any person acting on behalf of the accused, to refuse an interview, deposition, or other discovery requests made by the accused or any person acting on behalf of the accused, full and timely restitution from the person or entity convicted for the unlawful conduct, full and timely restitution as determined by the court in a juvenile delinquency proceeding, to the prompt return of property when no longer needed as evidence, to proceedings free from unreasonable delay, and a prompt and final conclusion of the case, and any related post-conviction proceedings, to confer with the attorney for the government, and to be informed of all rights enumerated in this section. And it continues. So I think we're well beyond 70-some words that are in the question, but I'll continue. The victim or the attorney for the government, upon request of the victim, may assert in any trial or appellate court or before any other authority with jurisdiction over the case and have enforced the rights enumerated in this section and any other right afforded to the victim by law. This section does not grant the victim party status or create any cause of action for compensation or damages against the Commonwealth or any political subdivision, nor any officer, employee, or agent of the Commonwealth, or any political subdivision, or any officer, employee of the court. And he continues. As used in this section and is further defined by the General Assembly, the term victim includes any person against whom the criminal offense or delinquent act is committed, or who is directly harmed by the commission of the offense or act. The term victim does not include the accused or a person whom the court finds would not act in the best interest of a deceased, incompetent, minor, or incapacitated victim. So as you see here, it's a lot more that is enumerated and could be enumerated because of the limitations of the question.
And I would, just if you don't mind, so there is the ballot question, but they're also here in Pennsylvania, that's different from other states, is we have a plain English statement that's crafted by the Attorney General's office that will be printed and posted in 3 different places in each polling place that describes what this all means in plain English. And that's part of the law here in Pennsylvania. So we are limited by the Constitution. We are limited to 75 words when it comes to the ballot question. Marcys Law didn't write it. The Department of State did. The Governor Wolf's administration wrote it.
Jennifer, is that something we could look at online?
Oh, yeah.
Yeah.
Can we go back to, can we, just to
For
go
the
back
victim,
to,
I want to go back to that.
Yeah, for Eileen's question.
I wanted to
Okay.
follow up on Eileen's question that ended with kind of specifically.
Yes.
Now that we've read it, specifically, what is it that you would
And then I was going to compare the question, because you don't actually get, in a sense, the entire, as you see, it's a lot.
So, but at this point, you'd say your objection is more to the process and the question that appears in the ballot than it is to the substance
Well,
of the
sure,
amendment?
I want every voter to know when they go to vote, what exactly they're altering in the state constitution. We have that, every person has it. Every person here and in Pennsylvania should understand what they're altering to become law and enshrined in our state constitution. Whether you agree with it or not, and it's my personal opinion, I do think there should be victims' rights, but I also wholeheartedly believe in constitutional values and this, enfranchisement. I want to be able to say, you know what, maybe I don't think, and there's provision in here that I don't agree with, that a accused or the victim, as defined, should be able to refuse to give discovery. Consider as a prosecutor, what would happen if I decided, we just heard in testimony from a practitioner on the defense side, what if I decided not to hand over my cell phone? We know a lot of information can come, right? And then, yes, defense counsel can subpoena records, but they can't subpoena records if they don't know the phone number, they don't know the cell phone carrier. And we are in a system, I think Tanner brought up, that we do need criminal justice reform. The accused in Pennsylvania already has massive hurdles to overcome. And consider that this would have the effect, and that's why even when it has been passed by ballot initiative or referendum in other states, this has been held under other state constitutions to be unconstitutional in its effect.
In what state?
Jennifer, I want to follow up on what James said, because I think it's an interesting point. It's one that I've heard from people with DCU that followed up. In talking about this, and the language is clear, refuse an interview, deposition, or other discovery request made by the accused. Now, in Pennsylvania, in the overwhelming majority of cases, you're not going to see a criminal deposition, right? Because they have the right to silence, et cetera. But with the other discovery,
Yes.
right? Jamie's point is a fair one. That's a pretty loose term that is not particularly defined as it is written here.
So You're a former prosecutor.
I am.
Can a victim refuse deposition requests by the accused or their counsel now?
Again, a deposition almost, unless you're talking about some sort
Discovery-
of financial
discovery
crime that
request.
leads to a discovery request. No, the Commonwealth, if it is a relevant piece of evidence, right, such as, again, there are hypothetical scenarios where an accused, or excuse me, a victim's cell phone could become relevant, it could become
Sure.
exculpatory.
Absolutely.
They would not be able to refuse to turn that over.
No, and they would not under Marcy's Law. So,
My question
But would
though
they
is,
know to even ask for it?
but my, well,
you
but
guys
let's
are
back
forgetting
up.
the fact that there is law enforcement, there's law enforcement investigations that happen. Everything that law enforcement, I mean.
Well, but hold on, the language, I mean, I don't believe I'm forgetting anything. This is the language of the amendment that
Well,
says,
you're not letting me finish. Okay, so in Marcy's Law, we do say that that all victims can refuse pretrial discovery requests made by the accused, not by the courts, not by law enforcement, not by anything. Here in Pennsylvania, victims can now refuse those discovery requests. Nothing is changing. It's not meant to change anything here in Pennsylvania. Victims can already refuse that.
With all due respect, that's not true.
That is
The current
absolutely
case-
true.
With respect to exculpatory evidence, and you were a prosecutor, consider again, I gave you a very common example, right? There's a cell phone. What if you don't have a common investigation, right? What if you don't have a thorough investigation?
So
Wait,
the
please let me
defense-
finish. I don't know the phone number, and I decide as the accused, I don't want to have anything to do with this. I don't want to give over my cell phone. I don't want to give over my email password. I don't want to give over the documents that I have. If I have a diary, not giving that over either. And under this statute, not only would they have the right to refuse that, but if they were forced to do it under a subpoena, a court order, that too would trump existing law.
That is absolutely untrue.
Jennifer,
Okay.
if
That's the law.
So there are crime victims' rights in 35 states here in the United States. This is in many of them. So crime victims' rights are in the state constitution of 35 states. The hypothetical situation that they're bringing up here has never occurred. So a court order given to, a victim, they still have to turn over that evidence. That is the law, and that's how it will be under Marcy's Law. A victim cannot refuse an investigation by the police. They cannot refuse a court order. They can refuse the accused representing themselves going and harassing them. And that's kind of at the heart of this particular clause, because in other states where the accused are allowed to represent themselves and they want discovery requests, pre-trial discovery requests made by the accused, they can harass the victim, show up at their house at 5 a.m., all of those things, and it's traumatizing to the crime victim. Look.
I just want to clarify, and I'm sorry, but, I want to allow you to follow up, but the hypothetical that you're talking about, that the accused would show up at their house and demand discovery, is way outside the bounds of any legal proceeding.
Please, I would like you to talk to any crime victim service organization, and it happens more often than you would like to know.
I was just asked to be on the board of a crime victim
great.
services. I'm telling you, there are harassing tactics that are used by defendants and
And the
accused.
reason that it probably doesn't
But-
happen in Pennsylvania as much as other states is it's not allowed here. And it is allowed in other states.
That
The
is in
35
fact-
states that you mentioned, is it enshrined in their state constitution? I'm curious.
This is what enshrined.
These rights that I just read off, not in the question, but the full statute, are they actually part of a state constitution where you can then enforce them?
35 states have constitutional rights for crime victims.
No. So my distinction is that they're not statutes, that this will be part of our state constitution. I gave you an example where a court would file a subpoena under this statute, under this now amendment, several amendments. The one that I'm speaking to, this would actually go over that, because a crime victim would not only have the right to refuse under this, but they would also then have the right to enforce that, right? So whether that's, get restitution, damages, we don't know, that would all play out. But you see here how there's not equity, that's a false argument to say that victims need equity. Yes, they do need support, they do need to be heard, they do have a crime rights statute. But I think this idea of the current due process that we have is being overshadowed because this hasn't gone into effect. We don't know. I'm giving you potential harms because this will be harmful, but it's also undermining the due process that we have. I mean,
Respectfully, I
But,
disagree.
yeah, but Jamie, I wanna push back a little bit. Oh,
It's a couple of questions, I know
Mike,
you.
Yeah, I
Sure.
think Mr. Spangler and Elaine, and also Mike, and also John. Okay, so we're not forgetting you.
Yeah,
And
you're amazing.
we have a half an hour, a little bit less.
Okay.
Who goes first?
Well, how about, Mr. Spangler?
Sort of a two-parter. At some point, discovery is enabled. I mean, if you can stymie discovery,
It's not, no.
then you may as well go home.
In Pennsylvania, discovery is served on the Commonwealth, not on the crime victim. That remains intact under Marcys Law.
So this refusal to.
It's not an issue.
I obviously
Right to
respectfully
refuse-
disagree,
right to
given
refuse
the
discovery
several
or
examples I've
custody by
given
the
you.
accused.
Yeah,
Discovery
that's
is
You're
served on the
talking
Commonwealth.
Are you talking about the accused as
Discovery is
an,
served on the Commonwealth.
are you talking about the accused as an individual?
With how discovery is served in
Right.
this Commonwealth.
No, I'm asking you for,
My question though is, it's
Are you talking about the accused as the individual accused, not his legal
it
representative?
says the accused or their counsel, yes.
Or their counsel?
Yes.
So I can say I can say that I'm not gonna provide the cell phone or the diary or the,
If there's a court order.
Yes,
No,
yes is the simple answer.
it's not true. If there's a court order, or if that information is within the exculpatory evidence collected by the Commonwealth, all of that gets turned over to the defense, even if the victim doesn't want it to be.
I want to point something out to you.
Everything is
If this
discoverable.
would even be a debate, which it's not, because you just read the statute, that in of itself is reason that should be concerned, because it's not clear cut. And so we need to know, how will this go into effect? How will crime victims know what are their rights? If we're already debating, what are the words that we see here? But I think we've already touched upon discovery and the potential, and I don't know if you wanted to talk about how discovery works,
it's a
but
pretty fundamental process.
Yeah, I respectfully, I agree with Mr. Spangler. Discovery, how it would work is there's an investigation that's conducted and the evidence is collected, but in some instances, in many instances, not collected by the police, and that investigation may need to be flushed out or enhanced. There may be times when the defense says, and not the defendant, and that's what I think the hang up, and I'm not really sure how you mean that. It is in the rarest of instances that an individual defendant, pro se, particularly in a criminal matter, without an attorney is going to ask for anything. The defense attorney will very often say, look, X, Y, or Z will tell you what my client is saying and will verify or corroborate what my client is saying. Your Honor, we are therefore asking for that. That's discovery, right? That's the nature of it.
Great.
I have to say, Jennifer, respectfully, this wording leaves me, I agree with Jamie that it is ambiguous. At the least, it is ambiguous, and
I respect that, however, I mean, the Pennsylvania District Attorneys Association disagrees with you. They think it's very clear. The governor disagrees with you, they think it's very clear. Senator Casey, Senator Toomey disagree with you, it's very clear. I mean, the intent of Marcy's Law is not to infringe upon anybody's rights. It's only to respect the rights of the victim. Why can't the victim have co-equal rights in the Constitution? Why is that so difficult to imagine? It's only equaling the scales of justice.
Okay,
It's
well,
not taking away any of
we're
rights.
gonna have Elaine have a turn because she's had her hand up for a while, and I just want
And
to
the gentleman.
indicate that intent really doesn't matter, it's really about what the law says.
So my question is two-part. One is that I thought the objection to the ballot question is because it's going to amend many, many little categories of our state constitution. And people who go to vote don't know that because it's one question, and it seems like it's gonna be one amendment. Is that correct?
that's correct, yes.
Okay, so if it's in the Pennsylvania law or constitution that you can't put a question on the ballot that is going to do blanket or balloon, changes, why is it there? And why did they unanimously pass or,
It's very interesting. That's a
because
great question.
if it is unconstitutional or against the law to have a question that's going to make so many changes that we don't realize when we vote,
Mhm.
then isn't it on its face not a ballot question that we should be voting on?
Correct, that's the basis of our lawsuit. So I think,
I mean, it
you know,
should
it is a question to consider, and I can't speak to this, but she said how they worked with so many legislators. What is our legislator doing? That they're putting it on us, right? You have to question your legislators. You have to ask them, why is it that you push this through knowing, and it's called log rolling, exactly what you said, that you have this bucket. I don't know why it's called log rolling though, because it doesn't actually.
Log rolling is more like a quid pro quo, which is not really what.
Well, I don't want to use that phrase now. But I will say that this kind of bucketful, because even the provision that we have been debating, maybe you wanted to say no to that, but yes to everything else, right? A lot of scholars have said that. You would not have that ability, and that is the crux of our petition, so that maybe it does work out, maybe it does go back to the legislature, maybe we do work on something that gives us a chance to individually decide what should be enshrined in our state constitution, and maybe what we don't see as necessary, as a necessary change.
But if that's the law, why is it on the ballot the way it is?
Because we don't
It's
see
part of our
it,
challenge.
we don't see it as violating a single subject. So the Crime Victims' Rights Act was passed as a single piece of legislation that includes all of the things. So it's one specific act, and that's what Marcy's Law is replicating, right?
Jennifer,
So-
the Crime Victims Act was passed by the Assembly and the State Senate, correct?
Yes, in
So it wasn't a
1998.
ballot question?
It wasn't, no, but that's what Marcy's Law.
It was legislated.
Right, it was
Mhm.
legislative, so it was one act, and it has to do with crime victims' rights. So just like the First Amendment talks about assembly and press and all of these other things, and it leads up to free speech, that's what this is, that's how we see it. It includes notification and being able to be heard in court and all that, but it all kind of ladders up to crime victims' rights. So we don't agree with the fact that this is some sort of log rolling issue. We see it as one single, we're adding one article to the Constitution, we're not changing a bunch of things, and single subject, not single section of the Constitution, right?
I just wanted to give John, who's been waiting patiently, a turn, and then cycle back to Mike, and then you also have a question here? Okay, so I just want to assure everybody that we'll get to all the questions, and would you like to have a turn now?
Thank you.
Great, cool, thank you.
This is great, by the way. On the point about discovery, it seems to me any criminal defense attorney would tell you that there's an extreme level of skepticism that they're actually getting all the exculpatory material, or that the investigation really was necessary and complete. Why would the investigators go further than they needed to? I don't know. But the bigger question, seems to me, is the legislature's already seen fit to pass this into law, and you said at the beginning that it's there's not a good remedy, right? The victims don't have a way to do anything about it if it's not followed. What will they be able to do if the constitutional amendment is
Yeah,
passed?
good question. So they would be able to assert their right in court.
Exactly what?
Yeah.
And can we talk specifically, John, because I'm glad you asked that, and there was one clause in here that jumped out to me particularly, was restitution, right?
Yeah.
And restitution, for those that don't know, is when you are the victim of a crime, very often you can ask for kind of reimbursement for various things. If it's a burglary, someone took your TV, reimbursement for the TV, right? Very, very often, we see criminals are not going to be able to make restitution, particularly in more serious cases.
Yeah.
So to John's point, what is the suggested remedy in a situation like that?
So just to be clear, in Pennsylvania law right now, victims are entitled to full and timely restitution. So it's already in law. So we would just be enshrining it into the Constitution. So what that would mean, it would mean that dockets aren't closed if restitution isn't paid. Because so often they start closing dockets when restitution isn't paid. It's not fair to the victim. So things like that, I mean, that would be a remedy. But that goes back to implementation and of Marcy's Law and.
Well, let's just say the judge doesn't do it, which is what you're
Right,
suggesting
sure.
happens regularly now. The judge just doesn't
Yeah,
follow
close the
that,
docket or
right?
something.
Then what?
So the victim can either themselves fill out a form and motion the court that their constitutional right was violated because they are entitled to restitution. And then the judge can decide.
So I think, just going to your point about restitution, we heard, we were both at the arguments yesterday regarding this injunction and the requested relief. So this is not about the merits, again, but about your question about how it's phrased. But, we heard from the judge herself saying, this is just unenforceable on its face about restitution. She just said, what Tanner pointed out, we don't get money now. So the burden of the idea of enforcing an unenforceable provision is something we also need to consider. And again, maybe we don't want that to be part
It's
of,
already in law.
again, that's very different than enforcing it. What, are you gonna hold a court liable? You're gonna hold a law enforcement? I mean, this is, again, our overburdened courts as it is. The responsibility, not only on a judge, this is flipping, right, our judiciary, this is flipping the tables and conflating our separate branches of government. And I think the intent behind the Victims' Rights Statute could be or the Marcys Law amendments, could be something that we look to do through a statute. But this enforcing and flipping the turn, I mean, we have to consider what is this going to do to our already backlogged courts. There's also a provision about requiring protection. How long, what is that going to do to our law enforcement? Which already, again.
That's only when considering bail, protection, yeah, it's a bail thing.
Again, consider our already overstrapped resources and what's happening in enforcement. Maybe that is one provision you as a voter thought, maybe I don't want to include and I want to say no. Maybe you wanted to say yes. But the point is, we do not get to individually decide, and that in of itself does make this unconstitutional.
Mike, you?
Yeah, so I haven't read our Constitution, the Pennsylvania Constitution, but I've read the federal Constitution, and one of its powers is brevity. And if you think about the federal Constitution, the rights of of criminals, the police say it every, you have the right to remain silent. And so brevity, I think, is a great thing. When I hear that, that doesn't sound like a constitutional thing. That sounds like a law. It should be, and it should be in the law. It's not in the Constitution. It just, that on the face of it just sounds wrong.
So the reason that, so from our perspective, the reason it needs to be in our Constitution because.
No, it doesn't. I mean, you're not making that be it.
But,
Jennifer's perspective, yeah.
Yeah. So, I mean, from our perspective, you can't have enforceable rights. You don't give victims standing unless it's in the Constitution. You can't give standing through statute. You can't give standing through any other means other than elevating those crime victims' rights to their Constitution. Crime victims deserve to have those rights, and what I'm hearing is that you want the crime victims to have rights, you just don't want them to be enforceable. It would be like having the right to vote, but if you're denied the right to vote, there's nothing you can do about it. So again, everything in Marcy's Law is in statute. We're not changing anything, and the 35 other states that have constitutional rights for crime victims can be any guy. These hypothetical concerns just don't come to fruition. They don't happen, because there's good case law to support everything that I'm saying, and, I mean, not the League of Women Voters, but the ACLU asked them for case law to support any of their claims that they're making, and they haven't been able to produce one instance where Marcy's Law or crime victims' rights have infringed upon the rights of the accused in any way, shape, or form.
I think getting to constitutional law on your question about the state constitution, and every state has their own constitution versus the US Constitution. Consider what's happening here. This has now been passed in, was it 12 states? 11? Yes, okay. So we know with the 19th Amendment how the League of Women Voters started. This was the ratification, right? And what was the end goal? The end goal was to make it part of our US Constitution. It's very dangerous what we are considering here, because in our US Constitution, as you brought out some of the rights, the accused is taking on that power of the government. And we know that's all powerful, right? It's not so surprising the District Attorneys Association would support this, but think about how our US Constitution would be forever changed to this idea of what is the balance here? We keep hearing that should be equal. We even heard it from the governor. Victims' rights, victims deserve equity. I think that was his exact saying. That is a false thing to say, because an accused, even sometimes wrongly accused, stands to lose their life, their liberty, even their property, right? And yet a victim isn't taking on the government. The victim is, going against maybe the accused, but they have the government behind them. The accused, they stand in many times, look, we're in a state that does not even have a state-funded.
So, Judy, are you suggesting that you're against the enshrinement of any rights for the victim in the Constitution?
I wouldn't go that far, no, but I do think we need to consider what the end goal is here and how dangerous that is without us individually deciding which of those rights we do think should be enshrined. So I'm not saying none at all, but I do want us to consider this is not about equity. It's a false argument. It's not even an argument, it's not even a debate. Because defendants, again, are taking on the government. They could lose their life, their liberty, their property, and a victim is not taking on the government. I mean, that's why we have due process rights enshrined in our US Constitution.
So my response to that would be that, yes, the accused should have due process rights. We're not opposed to having, for the defendant to have all of the rights in the Constitution. However, I would respectfully disagree with you that the Commonwealth and the prosecution isn't there to represent the crime victim. They're there to represent the Commonwealth. And therein lies the rub, that nobody is in the courtroom thinking about the victim. And if the victim's rights are overridden, there's nothing they can do.
I want to, let me just, because this is ending really well, but.
His question and Mr. Reardon's question.
Understand. So it's important to note that you are there on behalf of the Commonwealth, and part of that includes the accused, certainly, right? You are there to do the holistic duty of what is best for the community. However, it is false to say that doesn't include the victim. If you're not considering the victim and what the victim needs in your job as an assistant district attorney or a prosecutor of any level, you're not doing your job.
Absolutely, and I'm not in any way, I very much respect prosecutors. My point is that if a crime victim's right is unintentionally infringed upon, if somebody doesn't notify a crime victim of a court hearing, if they're not allowed to give an impact statement during sentencing, there's nothing they can do. How fair is that?
So, I come at this in a very naive fashion, but as I think about things, making constitutional amendments to me seems like it should be something very, very, very important, and it should be done very thoughtfully and very carefully. And I'm struggling with knowing that there is already a victim's rights statute on the books. I don't understand why that can't be beefed up to accomplish the objectives that this kind of an amendment would do without resorting to something that's a really big deal. And I think making a constitutional amendment is a really big deal. So that's a naive comment.
You're not naive at all. I mean, I think that, so what happened, the victim can't have standing unless it's a constitutional amendment, unless they have rights.
Why is there a law if it doesn't work?
Okay, so back in the 1990s, when states were really trying to look at crime victims' rights, so it kind of started happening after the Oklahoma City bombing. So the judge in that instance kicked all the victims out of the courtroom. It was too much, there were too many victims out of the courtroom. And so, of course, the public and the victims were outraged, like, this is not fair, we have the right to be in this courtroom. And so that really started the ball rolling for states to look at what do we have in statute, what do we have in our Constitution. Some states went the constitutional route. A lot of states changed their constitution then. Pennsylvania decided to go the statutory route, and that's fine. And what we've learned over the past 30 years where the statute has been in place is that it's not enforceable. And that's the reason why it needs to be in the Constitution. Because
so why can't you make a law that's enforceable?
There's no way to give a victim standing in court unless the rights are equitable with the accused. They wouldn't be able to assert their rights in court.
And I apologize everyone, and I don't know if I'm out of order, that I'm late coming back from work. But what I don't understand, and I'm going to piggyback over here.
Thank you.
If it's in the statute, the victims have rights. What I'm finding difficult to understand is you're sharing with me about enforcement of the right.
Right.
Okay. Why is it that the statute cannot stipulate how the rights should be enforced, one? And I know in Massachusetts, victims have rights. Mm-hmm. And if a victim has been injured, they do have a fund where the victim can receive compensation. I don't know if that's the case here in Pennsylvania.
It is.
But so I don't understand, why can't we fix the statute? what does it take to fix the statute as opposed to amending the Constitution?
Right. In order
Could
to
you
have-
speak to that?
Absolutely. In order to have the rights be able to be enforced, you need to give the victims standing in a court of law. And the only way to do that is to make their rights on par with the accused. So if so let's say, well, here in Pennsylvania, victims don't even have standing. So if their rights were to be dismissed or forgotten, they can't even address the court. There's nothing that they can do, right?
So this is the question I have, and I don't have that high of a legal background. When you state standing, I'm interpreting standing meaning that it's written in the law that they are recognized. Is that what you mean by standing?
Well, that they can be recognized by the court.
Okay.
So you need to have, like, for example, Marcy's Law doesn't have standing in this lawsuit because we weren't named and we're not party to the case. In order for a victim to have standing, meaning that they can assert their right to the court, they need to have equal rights with the accused so they can assert their rights. The states that have passed these statutes, it just isn't enforceable in this way. And so,
So I think I'll let you go,
I'll let you go.
well, we were just talking about standing. I am an attorney, and I've done many cases about Article 3 and standing and enforcement, everything from a class action to a civil case. You do have standing if you've been harmed, okay? So I think what's very interesting, and we have to remember here,
in a criminal case or civil case?
but again, if you have been harmed, you can have standing. What we're keying here is, this on par, we heard it, on par with the accused. Again, I have told you, you cannot equate a victim with an accused. So maybe going back to your original question of, you just cannot.
I agree. The rights
Oh, wait,
are different.
Okay, I'm very confused, because before you said we want to put them on par.
On par, but they're not the same rights, Jamie. They're not the same
But
rights.
that's the issue, I think. Not monopolizing, but in my mind, what I'm hearing, that is the issue. The issue is that as a victim, I want my rights to be equal to the person or persons I am saying injured me. And so
Right.
what I'm hearing is, this, right now, you're saying to me, I don't have standing.
That's correct.
But what I understand is I have statute,
Yes.
and the statute gives me standing.
The statute does not give
In
you
my
standing.
mind,
Yeah.
it gives me standing, and then the other part is that I have the prosecution that represents the rights of the state as well as me, the victim. So I'm confused over why I can't fix my statute. I don't understand that piece.
So there's no mechanism for a victim to assert their right in criminal court right now. If a right is violated, so let's say a victim is refused, the judge says, no, you're not allowed to read a victim impact statement at sentencing, and that has happened.
It has.
Yeah, and unfortunately, it does happen. And so the prosecutor can't say to the judge, excuse me, this victim has standing, they deserve to give that victim impact statement. The judge can say, nope, sorry. There's no legal, it's not legally bound and not bound by the Constitution for the prosecutor to say, no, this person has constitutional rights to give a victim impact statement. You must let them do that because that is their right. It can't be done under statute.
I'll let you go.
I will respectfully disagree as to that specific point. If I were to say, Judge, under this law, they should be able to give it. I'm not saying the judge will agree with me. I'm not saying the judge will let him do it. But I don't know that this amendment would change that judge's ruling based on the law. That changes if you are going to bring a civil suit, right, saying
Civil's different.
my rights have been violated based on this constitutional amendment, that's one thing. But if we're talking about in a criminal court, being able to say, Judge, by law, I'm able to do it, the statute should be effective. The statute should get.
It should be. I mean, let's say it should be. Let's all, okay, statute's sufficient. Well, crime victims' rights are violated every single day. I talk to them.
They are.
There's nothing that they can do. They don't have standing to enforce those rights. They just don't.
Okay, you mentioned case law.
Yeah.
Okay, can you share with us a case law that speaks to the victim's right not being addressed in his example? Can you provide us a case law with that?
Well, I can provide you an example,
You know,
right?
I like a case law. I like a case law.
Well, there's no case law because they don't have standing. So
There
there's
would
no.
be case law from the standpoint of the crime took place,
Yeah.
the victim wanted to give a victim impact statement. The record of the court would have the judge saying, no, it's not permissible.
Oh, yeah, there's
If that
examples
would
like
be,
that.
that would be in case law, so I'm asking, is there a case law to that? Do you have an example?
Yes, I do. Yeah, absolutely. Yeah, it does happen.
I absolutely agree. Judges do that. They do.
And
I don't know that this remedies that, to be
Yeah,
clear,
I think
but
this
this
is a
does
really
happen.
important point though. Judges do different things and judges interpret the law differently.
Yeah.
We do not know how this will play out. That was something that came up in the hearing from the judge herself. That we have concerns about how this will further lead to inequities in the system. And that includes inequities for victims, right? If you're not notified per this statute that there's a hearing, parole, bail, what does that mean, what would happen for the court case, right? Because we know under even state constitutional law, there's a right to a speedy trial. Trials could be held off because the judge fears, well, if I don't do everything I'm supposed to do, there could be ramifications. And that too affects, what if there has to be retrials? That further harms the victims as well. So there's a lot of concerns in the implication and the impact of what we're doing here. But again, maybe there are, and I keep going back to this, maybe there are portions that could be done statutorily. Maybe there are sections that you're having pause about. We will not get to decide separately to include or not include those sections, given the way that it's lumped together.
I just wanted to say, we are almost out of time. I don't care if we go over, I'm allowed to go over a little bit, if all of you are raring to go. Margaret had a question. I see that you have maybe a follow-up question, and I actually had a question as well. It's a two-part
We organize this, thank you.
I'm Margaret Alessandro, I'm a resident of this town. So without remedy, there is no right, is part of the basis for this. So if the remedy, part of the remedy that you spoke to was restitution, and yet there seems to be a stipulation in this amendment that says that victims will not be able to sue a judge or hold them financially liable for violating the rights.
Right.
So it seems to me that that's in direct contradiction to the provision of the remedy.
The remedy wouldn't necessarily be restitution. Restitution
Well,
is
so
one of
that's
the,
an example.
restitution is one of the rights that are provided for the crime victims underneath this amendment. So, but the remedy would be the ability to assert your right in court. So if your right is violated, you can motion the judge, you can motion the court to say, my right has been violated. And that's the single remedy. Victims only want to
But
be
you're
heard.
taking away the ability to get a financial, so.
Yeah, it's not about the victims
Well,
collecting
maybe
money.
it's about restitution.
Well, the restitution, maybe you can help me explain. So restitution is very different from the remedy of Marcy's Law.
But I think Margaret's
I thought
question
that was
is,
part of.
no, but yeah, I
Different
think
part of
Margaret's
the
question is, if restitution is ordered
Yeah.
and that right is violated,
Yes.
your
I
action, what we talked
understand.
about earlier, was the remedy for that would be able to say, judge, do something.
Yes.
But I think Margaret's point is, to have standing, you have to have standing in a suit, right? I mean, that's the remedy, would be to kind of have some sort of civil action to get a remedy.
Sure.
But if the judge, the party that
I'm
is
just not sure what this
ignoring
is.
this right,
I get it now.
Yeah.
So the crime victim cannot sue the Commonwealth or sue the judge or sue the prosecutor. That's what that means.
For violation of victims.
For violation of victims' rights. It's not
Yeah.
about the victim getting money. It's about the victim being hurt. It's about the victim
Well, it may be about the victim getting money. Basically, this says they can't sue for anything.
Well, they can't sue now. But
Right, so I'm asking you, why are we amending our Constitution and not putting that stipulation in? Or, what's the point?
So, yeah, this is a conversation that happens often within, victims' rights groups. It's not about the victim getting money, because they can sue civilly and get money if they really wanted money. In the criminal proceeding, it's about being heard. It's about not being forgotten. It's about having a voice and being able to be a part of this. The victim's the only person in the courtroom that's there out of no fault of their own.
Well, this is for Vid's lawsuit, so it isn't just about that, I was using that as an example. So, again,
They can't sue the state and they
No,
can't
I
sue
know.
the judge, yeah.
So, but you're putting this very extensive amendment into our Constitution, which seems to have a very big loophole in it. I'm just not sure why that is in there.
Because the purpose is not to be able to have any punitive repercussions for anybody if the rights are, some
So
way
you're saying they don't have
violated.
standing now, so they don't, but, they won't have this right.
Well, they
So
have.
Jennifer, let's say it was violated, as Margaret says, let's say the judge just blows it off, what is the remedy?
So the remedy, so the victim could work with their advocate, or they could work with the prosecutor, and they could motion the court to say, my right has been violated, judge, please reconsider whatever the specific right that they're motioning for. So if it's, I wasn't able to give my victim impact statement, let's say they weren't able to give their victim impact statement, they can motion the court, the judge can take a look at it and say, okay, I'm gonna have another sentencing hearing. Not to have a new sentence put on the convicted at that point, but for the crime victim to be heard. So victim impact statements are a non-weighted factor when it comes to sentencing. So the sentencing wouldn't change, right? So it would just be an opportunity for the victim to give their impact statement. That is something that's very healing to crime victims. They have every right to have the judge hear how they felt after a victimization, and have the defendant hear how their crime impacted them. That's all. You can motion the court.
So I just want to say, just to be clear, under our current statute that we have, I think the difference is you do have the right to make an impact statement. I
Yes.
think the difference is, what you're saying is it should be enforced, and very clear, we just heard an example, reopen sentencing. I mean, this has significant consequences, not just maybe on appellate procedure, how many times appeals, how about plea deals? How about how many times a defendant takes a plea deal, maybe there wasn't evidence given over? We don't know, right? We can't foresee the implications that, again, may very well impact victims as well as the accused. So
I'm confused with the issue with the plea deal, because there's no victim impact statement with it,
no, I'm just saying with the implication of the entire lump sum of what we're considering here. I was saying all of it together, and I think already the confusion that we're seeing here is another example of why this should not be something that we shouldn't individually consider. Maybe that portion, as you're noting, you do find it conflicting. And these will be merits that will be fully considered and played out by the attorneys. Yes, I'm an attorney, we're attorneys, but I'm not an attorney as far as the substantive merits. We're talking about a debate here. But the case that's before, it goes right to your point about not individually assessing and why is it a constitutional amendment, and it is challenging that procedure of the question and not the ability to individually decide these obviously very important alterations to our state constitution.
Yes.
Yeah, so, you read, I'm gonna say roughly a dozen different rights, and that may not be the right number, but whatever the number is, can somebody comment on where other states have already added such a constitutional amendment to their constitution? How many of those same, say the number is 12, is it the same 12 in all the other states that have been passed? Have there been changes? Modifications here, modifications there? That's sort of question number one. And question number two, picking up on her question, is there case law with how it's actually working in the states where the Constitution amendments has taken place?
Yeah, so every state's constitutional rights are a little bit different, just like every constitution's a little bit different. But going back to what's at the heart of Marcy's Law are those 10 to 12 rights that are considered to be more than acceptable and should be enshrined in the Constitution by the National Crime Victim Law Institute. So it's basically all the rights that you've listed. There are some additional ones that aren't necessarily included in our Marcy's Law. We don't have a specific provision for privacy. Other states' Marcy's Law, they do have that. South Dakota amended, they had their Marcy's Law, they had to amend it because they had They were asking for mandatory notification for all crime victims. They didn't have any infrastructure like we do here in Pennsylvania for crime victims. And we have an opt-in, so it became very cumbersome for them, so they amended their Marcys Law to have an opt-in notification, things like that. So the rights are all kind of there, but you know, you kind of pick and choose for your state as far as those 10 or 12 rights.
There are several states where it didn't even come out of the legislature, as there was more of a debate and more of a dialogue like the one we're having now. You know, I believe New Hampshire, Montana I brought up as an example. There are states that are really struggling with the actual application of what this means, the financial burdens, the resources.
Well, the South
Not
Dakota
just-
case is what I just kind of, that was the one, the financial implications.
So I was talking about the implications of what this would mean, and that again includes all citizens, so it definitely includes victims. But the resources and the idea of this idea of balance, you know, what does that mean when you actually look to a judge, right? We're kind of taking away some of the judge's responsibilities, okay? And that has very far-ranging and wide implications.
Can you please explain that? I don't understand what you mean.
So I was just, I gave one example of subpoena power. Subpoena power of the court, but a victim under this statute could rightly say, no, I don't want to, we could talk about a cell phone. No, I don't want to give you a cell phone. So where does that come out? You know, you're actually trumping.
Subpoenas.
But that's what I'm saying. A court order is a court order.
Right.
Okay, but this allows you to say,
That's not true.
I refuse that
There's no
court
case
order
law that
because
says
I
that.
have a right. So you're saying the statute isn't effective? Now I'm confused because it allows you to refuse discovery.
Exactly.
So if you're subpoenaed to provide certain discovery,
By the accused, not by the court. That's the distinction. And there's no case law.
I'm sorry, we don't need to mince words. It's exactly as I said.
But it's no, you can't, a victim right now cannot refuse a court order
Maybe
for
you can,
discovery.
in your prosecutorial experience, if this came before you and you were subpoenaed and the victim said, I do not need to give over that discovery, wouldn't this actually trump that subpoena?
As I think I made clear earlier, I am a little bit troubled by that language. I mean, that to me leaves open-ended. The question, I think it would need to be resolved, right? I think that would be something that would be, that would develop into a case.
And there's plenty of case law in other states to support what I'm saying. Like, that just doesn't happen. Court orders are court orders. Victims will have to respond to that. Marcy's Law wouldn't change that.
But again,
I guess my question, Jennifer, though, to
Yeah.
follow that up, is that discovery requests by the accused.
Yes.
Let's call it through their attorney, right? Because again, by the accused is exceedingly rare. Through their attorney, one can simply say no right now. I mean, that has no effect. It's the court that is the enforcer of that. So to say you don't have to listen to the accused discovery request.
Yes.
Well, a defense attorney can call me on the phone right now and say, I want X, Y, and Z, and I can just say no and hang up.
Right.
But so
it already
I'm curious,
happens.
but I don't know what the efficacy of that provision is.
Right, so in Pennsylvania right now, crime victims can refuse discovery requests. If that would be omitted from our Marcy's Law, it would be like we were giving the accused that individual right or omitting the right for the victim to refuse the discovery. So that was the reason that it's in there,
Okay.
so, yeah.
Beth, you had a question?
Yeah.
Okay, so my question is, this beefing up of rights for victims beyond what's already stated in the 1989 statute, when these niceties from the prosecutor's office don't happen, like calling up or written notification that the accused, that the criminal defendant is out on bail, or these other things that we'd like to see happen for victims, this is a two-parter, by the way, what is the typical reason now that these things don't happen? Is it because they don't want them to know?
Maybe you should have, there are requirements.
Yeah, so Beth, look, it's case to case, it's prosecutor to prosecutor, right? Very often, you were talking like in Philadelphia, with lower level stuff, right? You are talking about a volume that is immense. You are talking about unreliability in terms of being able to communicate with a victim. Very, very often we have a difficult time reaching victims. The reality is, under this, the burden troublingly kind of shifts. And I don't mean to kind of pick on Jennifer, because I'm not I think it's important that we work towards victims, and I think their voices aren't heard. I think the points and the underlying principles of
I've
this.
worked with the criminal justice system in
Yeah.
Philadelphia, I know how incomplete the practice can be, and I'm
So-
still waiting for the rest of the restitution.
And I have to say, on kind of the higher level, when that doesn't happen, and I think part of the reason that this is spurred, and I applaud it, is I think we have seen recently there has been some neglect. And there have been times when it has been calculated. So that
Would you
concerns me.
say that this is something that might be changed if the budget of the DA's office were enhanced?
I don't think that's entirely fair. I don't know.
Okay,
that
so
entirely
it's
would be
really
fair.
not a money thing.
I don't think it's a money thing.
Okay, because where I was going with this is, if this is a ballot question and it's actually going to wind up a constitutional amendment, but there's no funding attached to it, that would amount to an unfunded mandate. And I'm not persuaded that it still isn't.
I worry about the efficacy and the teeth. I go back to Margaret's question of if we're saying this is about kind of putting behind a mandate, where's the mandate? If there is no remedy to this, and to Jennifer's point of this is about being heard, I understand that, but I think the desire of the victim to be heard where they are actively suppressed is a concern, a great concern, and one that should be taken very seriously. But it is not, I don't think it's overwhelmingly common. I think more often what you see is a process moves along and people get left behind.
Agree.
And if there is a desire to be heard, I think generally because that is the nature of the problem, there are ways to remedy that. Or I think there will be attempts to remedy that. And my concern here, and this is kind of, again, going back to Margaret, if the goal is to make it enforceable, and the goal is to say, even if you don't want to kind of slow the process down and make them heard, we're going to make you. My question is, with this law, how? And that's where I'm
This is
like,
also my question. I mean, when you said right without a remedy, that's a super salient description. And where my mind goes is this the thing that yields 10,000 lawsuits by victims who felt they weren't heard?
Yeah, so it's not retroactive, so it wouldn't be retroactive. However,
Well, I mean, even so.
right, well, I mean, again, so the 35 other states have constitutional rights for crime victims. In the states that have passed Marcy's Law, you don't see this big influx, because I have to say that one of the benefits of having Marcy's Law is it's preventative as well, because judges don't want to be called out for violating crime victims' rights. Prosecutors don't want to violate crime victims' rights. I mean, they don't want to anyway.
Does this give grounds for a lawsuit on the part of the victim? I mean, every state is in Pennsylvania, and I think we all know what a reputation is for lawsuits.
Yeah, so I mean, Marcy's Law is very specific that a crime victim cannot sue the Commonwealth or any entity under the Commonwealth if their rights are violated, but they can motion the court. So, okay, so let's.
So is that the only remedy? Because
Yes.
I'm feeling like they probably could sue someone based on my reading.
I mean, you can sue anybody in civil court. I mean, that's still an option. But the purpose of Marcy's Law is to address those rights violations in criminal court at the moment that the violation happens, right? So it gives the crime victim the right to file a pro se, to say, my right has been violated, you need to remedy this. And so this isn't about sweeping changes to our criminal justice system. We haven't seen that in the 35 other states where there are constitutional rights for crime victims. And you don't see a lot of these violations happening, but you do see, I mean, there are a lot, like you said in Philadelphia, I mean, it's just, there's a lot of crime, and sometimes people don't get notified. It's not right. And it's not necessarily a funding issue. I agree with you.
I don't think anybody's disagreeing that the system has let victims down. I mean, even my first summer of law school, I worked at the Philadelphia District Attorney's Office. It was probably the most eye-opening experience. I worked in the Family Violence and Sexual Assault Unit. And yes, it was probably it was my segue into what are the injustices on both sides of the system. And one of the petitioners, including the League of Women Voters, is a woman who has been on both sides, is both a victim, but has understood the problems that we have with and needs for criminal justice reform. Massive mass incarceration rates. We are in a state where we're lucky. We're in a county right now where you do have the resources because it's county by county for defenders. So what about those counties that don't have the resources? And I'm bringing these things up because we see both sides and the resource, and I think we've heard this from tonight, the necessary changes that need to happen. But I think the efficacy and the need for those changes does not come with sacrificing constitutional rights. And so I go back again to, is it a statute, right? And I do think that, with all due respect, there have been significant problems in states that have passed this, whether it's exactly the same or not.
And I don't mean to cut you off, but with the exception of the discovery rule, which we've discussed quite a bit, with the exception of that, how is this, and I agree with you that they're not equities, right? It's not on par, but how is this, with the exception of the discovery, how is this curtailing a defendant's rights?
You brought up a good example that in your practice, you can often not find the victim. Under this statute, your behavior would change, and a trial in and of itself could be delayed because you're required. I'm giving an example, okay? That there are real implications that also affect a victim, right? Because the victim is required to be notified. So that in and of itself could also affect a speedy trial, which is part of our law as well. What if that person is sitting in jail and they're wrongly accused? We know that happens in our system. So there are ways to go about this and make sure we give the resources to victims. Again, I have seen firsthand that we do need to do a better job with victim services. We do need the funding on both sides. Our parole system, what is it? We just saw the stats that just came out. 1 in 25 people in Philadelphia is on parole. How is that helping either side, right? That's not helping us. That's double the rate of the entire country, by the way. So there are bigger implications here, but again, we cannot sacrifice our constitutional rights. That includes enfranchisement and due process in considering also victims' rights, okay? Because victims, again, also have constitutional rights, but this should not be something that should be enshrined in our state constitution.
Julie, I had two other things. One, Fran was saying that he was, I'm really excited to hear about the results of the hearing in Harrisburg. And the other thing is, the way you're using enfranchisement may have some of us confused, like me.
Okay.
Because I hear enfranchisement and I think right to vote. So.
Technically I should say there is no fundamental right to vote, okay? There are, like the 19th Amendment, I see some of you nodding, right? And so I've been fortunate enough, I've been election protection director of the state, and so I often tell people, ooh, be careful when you say, I have this right to vote. Yes, there are rights, and enfranchisement means access to, okay? That and this is an example of that. That's what the League advocates for, began with the 19th Amendment, and has continued on to make sure that we prevent voter suppression that comes in all forms. This constitution, I go back again to your point about this separate, this bucket full, this grab bag of sorts of separate alterations. That's what I mean. And you often have said disenfranchisement, right? That you're taking away that access, that right to decide individually, which we do. It's very powerful that we as citizens are the only ones who can alter our state constitution. Pennsylvania having one of the broadest and most liberal, we saw with the redistricting lawsuit, also from the League, that used the power of our state constitution to prevent political gerrymandering. But again, this idea, what I'm talking about is that access to and that right to decide each and every alteration, which is part of constitutional law. But I hope that answers that about access to. But I think, I'm sorry, what was the other question? You said something first.
Rich had a question, and
Oh, the
we wanted
case.
an update on
The
the
hearing,
case in-
the hearing, yes. So
Harrisburg.
we were both there at the hearing, so there isn't one, it's very important that this is the preliminary injunction. Injunction is to enjoin to stop. So again, the merits that we have gone into today haven't actually been decided by the court, but we are asking for particular relief so that the actual results, so you will all go vote, you can vote, and please vote, please. I think if you're here tonight, you're interested and you will vote. That it's really about not certifying those results till we really work out the crux of the issues that we have discussed here and the merits. And so we are saying that the Secretary of State, whatever those results are, look, I think if I read this without, having the background I have, yeah, I'd probably vote, hell yeah. I mean, all I see are, and kudos to them, I mean, all I see are, Sunday Night Football, I saw Marcys Law ad. So I think people are probably overwhelmingly going to vote yes, and understandably so. I mean, like I said, who wouldn't be stopped and said, no, I don't support victims' rights? But that's up to, this is a hard conversation, it's a hard stance to take. The ACLU, we also have wonderful pro bono counsel of Deckard LLP, and so we'll see, we don't have an exact ruling yet on whether it will be.
So it's pending.
Yes, it's pending, but I'm sure it will, because the point of bringing in a preliminary injunction is you say there is immediate and irreparable harm.
Okay, and then I guess one last, is that okay? Last question from Rich, and thank you all.
You don't
very
want us to
much.
keep talking?
Okay. So Rich's question is,
Yeah.
I just had one yes or no question for each of you, or true or false. Bottom line, would you say that Marcy's Law is good but not good enough, or good, let's do it, for each of you?
Marcy's Law is incredibly important for crime victims. It's good enough, and I hope the voters agree.
Okay, if good enough.
I would have to say neither of your choices, because it's not good enough, and it's not good, but it needs, I think the other one was it's good, but it needs work. I would say that it shouldn't be done by constitutional amendment, and we need to go back to the drawing table, and we need to make sure to do this correctly via statute.
And I'm going to invoke my moderator status.
You gonna violate that?
No, I agree very much with the underlying sentiments, and I truth be told, Rich, I have not decided kind of which way I'm going to vote on it, because I do have reservations about the language, but I also, I have very grave concerns about the way we are sweeping away the conversation around victims right now.
Okay, so you say good, but you're not sure if it's good enough.
Yeah, that's right.
Exact split here.
May I ask for one clarification? When we refer here to Marcy's Law, is that a law in Pennsylvania?
No.
What is Marcy's Law?
Marcy's
Where is
Law,
it a law?
Yeah, no, Marcy's Law is just the term that is used for the effort trying to amend the Constitution.
And it's really Marcy's amendment, not.
Yeah.
Well, it is called,
It
it is called Marcy's Law for All,
Yeah.
is the overall nationwide campaign, correct?
It's a
Yeah.
campaign name.
Right.
It is a campaign,
Thank you.
yes,
But
it's
is
a
it only
registered
a
lobby.
constitutional campaign, or is it a law in some states?
oh, I just have one final point from
How
Margaret.
closely does Marcy's Law for All align with the constitutional victims' rights amendments in California and Illinois?
Oh, no.
I'm sorry?
There have been victims' rights amendments passed in 2008 in California and
Yes.
14 in Illinois. How closely does Marcy's Law for All
I mean,
align with those?
There is model language, right, for Marcy's Law,
Oh,
those
that's
12
okay.
pillars, right, but it's tweaked in every state, so not every state's Marcy's Law is identical in any
Are
way.
those constitutional amendments as multifaceted
Yes.
as this one?
Yes.
Thank you.
Is there like another state that is most close to Pennsylvania's, that where it's already been implemented?
Yeah, I mean, again, they're tweaked to be appropriate for each state. So like I said, Florida's is very similar to Pennsylvania's in a lot of ways, but it has a very explicit privacy provision. So, so that makes it very different. And the reason that
And that's privacy for victims?
privacy for victims,
Okay.
the reason that we don't have privacy provision in our Marcy's Law is because we don't have a privacy provision in statute. So again, we wanted to make sure that we were taking everything in statute that isn't enforceable, as a right without a remedy, and elevating it to the Constitution so it provides the enforcement mechanism.
So of the 12 points, how many of them are currently in the statute?
All of them. The one exception would be the discovery, and that is in rules of criminal procedure. Well, actually, it's absent from rules of criminal procedure, which makes it a right for a victim to refuse. So yeah, I mean, it won't change anything. Only giving the victim the right to assert their rights in court.
So we,
That's awesome.
I really appreciate everybody coming out this evening.
Let's say
And
that.
Thank you for doing this.
what I wanted, because I wanted to
Well, I
know more,
think it's
so
really
you're so indulgent to come.
Because we can say, there have been, very few, it's maybe tacked on to like candidate forums, but there have been very few like straight up forums, and so I thank Beth for contacting us and doing this, because it allows you all, you're the voters, right? I'm a voter too, but to ask the necessary questions and decide for yourselves. And then here, it's not an easy position to be in. I mean, I have been labeled anti-victims' rights, which couldn't be farther from the truth. But it's really important to understand why there is a Marcys Law, as we've heard, but also, why there is this challenge to the ballot question.
Thank you all.
Enjoy the lead.
Well,